Let's go back. So we were talking about earlier the issue of standards of care within practice. The difficulty with that, and I think that's run across in the judiciary, that has been excluded as a criteria to exclude an expert report. And there's been appellate case law in which experts have testified to the appeals court that, hey, this report doesn't fulfill the standards of care. There's so many omissions and false statements in the report, it's not valid. But they haven't considered that as reason to exclude a report. So, but in the so in the family code, it says that the reports must fulfill the standards of care of that person's licensing board. Right. But yet, in the case law, unfortunately, and there's some particular case law more recently in 2019, in appellate case law, and I think I won't mention the district, I don't want to get it wrong, but in which that didn't matter. So what do you do? Okay.
So basically, it could be a garbage report.
It could be a garbage report, but the judiciary will say it's a valid report and uphold it, but they're not under any obligation to follow the recommendations. They're not an under. So going back to the discussion or the question you said earlier, and I think some of this relates to why would they just assume a report is valid? Okay, unless it's or not valid, unless it's properly scrutinized. So what is the educational expertise and the professional expertise of judges and attorneys? Well, apparently that's the legal system. Okay. Yeah. They're not experts in mental health. Okay?
Yeah, exactly.
Where I think that if they're dealing with family law, they should be trained in mental health to some extent. Yeah. To interactional mental health, and I've ran across and seen videos or educational videos of lawyers that have much more familiarity with mental health. And I've been fortunate to have an attorney who was much more astute as well in the past. But so, you put out these reports, you're supposed to be the expert, others are not the experts, sometimes they just don't know better, okay? But because you're the advertised expert, kind of unknowingly, they just assume.
Right. So should there be any liability on the part of an attorney who submits a report like this that does not meet the criteria that you're talking about? It's not an expert report.
Oh, we know already that there should be, and it involves the issues of sanction,
Because that's what happened in your case, so.
Well, yeah, and the Texas Rules of Civil Procedure as well, or the Texas Remedies Code as well. If you're going to submit reports, which Alyssa Sherry's report was attached to a motion by opposing counsel back in February. And essentially, that made his motion invalid. Now, I guess the issue of did he have credible knowledge that the report was not, or was contaminated with many false statements, or did he not?
He played to his case. We know that. That's what he is most interested in, because attorneys are interested in winning. Justice in the justice system is almost sometimes as illusory as privacy is today in everyday life. I mean, I've heard attorneys say, "Hey, I'm in there. I want to win."
Yeah.
Well, winning and justice can be two different things completely. And in this situation, the opposing counsel, Marshall Thompson, I think it is. So he's in there. He wants to win, and he wants to stick you with fees, and he wants to have another thing that he can trump, that I've won this case, so I can increase my fees. I have a reputation and everything else. But whether he knew that the report was not credible or not, he submitted it as it being credible.
His signature's on the motion.
His signature's on the motion. So therefore, to me, if you're submitting false evidence or false testimony as part of your case, you have an obligation to immediately address that. There needs to be some other type of sanctions as well, but I also think that there should be some liability when you do that.
Well, yeah, I mean, if you're submitting false information to the judiciary, there are statutes and rules that govern that.
But then again, the judges don't know if it's false or not either. So.
And there are penal codes that govern that as well. You know, the aggravated perjury issue, the perjury issue. And I don't think we're obviously not alone in that issue. I mean, you hear about it all the time. Craig Ellis, the actor, wrote a book, you know, The Respondent, about that exact same thing.
Yeah.
You know, this whole proposal that we're conspiracy-minded people would hold if we were the outline and there wasn't any substantiation.
Right. What is the majority of people across every state in the country?
When you talk about hundreds of thousands of people talking about experiencing the same issue, where what happens is the child suffers. The child is being thrown more likely into these single-parent households. For
devastating.
It's devastating for other purposes. I don't think it's a conspiracy-minded issue. I mean, we know in the Family Code definitely that, you know, it's clearly stated that associate judges are going to optimize child support by whatever means necessary. I mean, it's legislative law.
That's very interesting. 201-107C of the Texas Family Code, that an associate judge shall or must rule in such a manner so as to maximize Title 40 funding reimbursements to the state. That has nothing to do with the proposed best interests of the child.
No, it doesn't. And let's talk about, you know, a statement in the report, you know, no parent is entitled to 50-50 possession. Well, that's the, you know, the tribal culture that we've heard about multiple times in several counties in Texas, and that's the culture of the Texas Family Law Foundation as well. So, you know, if you're iterating comments that are also iterated by one of the main lobby groups that have been fighting against shared parenting, you know, that's a pretty strong indication of a pre-existing bias or a collaboration. You know, and in the last hearing, in which I wasn't able to testify, and I objected to not being able to testify, and in which there was evidence presented as exhibits that I wasn't able to cross-examine. But the expert witness, Alyssa Sherry, was not allowed to be admitted, nor was the report. But yet, the opposing counsel is testifying for interim fees for the custody evaluator, and admits in the trial, the hearing, that there had already been pre-existing communication, one-sided communication, with the custody evaluator, in which actually the custody evaluator should have equal communication with both parties. If there's substantive communication, it should be both parties, which does not occur. Well, that tells me that there's a collaboration, and there's a collaboration in order to benefit financially. And that collaboration did not occur with both parties, just one. And that in collaboration to benefit financially included benefiting financially while taking monies away from the third party.